Muted.
Welcome to our webinar on immigrant access to federally assisted housing. We are partnering today with the National Immigrant Women's Advocacy Project in Washington, D.C., or otherwise called NIWAP, to bring you this presentation. NHLP and NIWAP are national technical assistance providers for OVW grantees and subgrantees. If after the presentation you have questions or need further technical assistance on any issues that we discussed, our contact information is at the end of the PowerPoint slides today. There are also links to our various resource libraries at the end as well. That there's a lot of information that we have on our websites and libraries that are easily accessible to you. This session is being recorded, and along with the materials from today, we'll share those with all of the registrants. So for anyone who missed the live presentation today, don't worry, because you'll have a chance to listen to the recording at your convenience. Today I'm joined by Gideon Anders, who is a senior staff attorney at NHLP, as well as Leslie Orloff, who is director of the National Immigrant Women's Advocacy Project at American University, Washington College of Law. We also have on the line Rosia Molina, who is NIWAP's associate director. She will be available to answer your questions that come in via the questions box. And we also have Robin Murphy, who is Chief Counsel of Civil Programs at the National Legal Aid and Defender Association, or NLADA. And she is available for LSE-funded programs that might have questions regarding whether they can or cannot, what they can and cannot do in terms of serving immigrant survivors. So if folks have questions about that, please feel free to enter those questions in the questions box throughout the presentation. Before we get started, let's go over the GoToWebinar interface. You should have on the left side of your screen a viewer where you can see the PowerPoint presentation. On the right you have a control panel. This is a great time to test the audio quality of the presentation. So if you're having trouble with the audio, you can use the telephone or the computer's mic and speakers. To use the computer's mic and speakers, you can go ahead and select mic and speakers on the audio pane. And you can minimize the control panel by clicking on the double arrows, and make it big again by clicking on the double arrows. Your other option for audio is to use your telephone. And to do that, you just go to your audio pane and select telephone. You'll see that there's dial-in information that will connect you to the webinar via your phone. Today you are all muted because of the size of the audience, but we welcome you to submit questions via the questions box, and we will answer those throughout the presentation. And if we have time at the end, we'll answer questions at the end of the webinar as well. Just a few housekeeping tips, and then we'll get started with the substance of the presentation. The materials for the webinar were emailed to registrants earlier today, and we'll email them again after the webinar along with evaluations. And just a note about that, if you registered for the event within the last hour, you probably did not receive the materials because I sent them out about an hour before the webinar. But have no fear, we will send those materials as well as a recording round again to all registrants after the presentation. The materials and recording will be posted on NHLP's website at nhlp.org/OVW-grantees. I believe NIWAP is also going to be posting the recording and materials on their website as well.
Right, and our web library is library.niwap.org. It's on the materials, and we'll get it to you as well.
Thanks, Leslie. And NHLP will email MCLE certificates to California attorneys. I think folks who wanted to get MCLE probably entered their California bar numbers when they registered, but if you did not do that, you can feel free to email me at kng@nhlp.org and let me know that you are seeking MCLE credit for the session. If you are out of California, or you're barred out of California, you're seeking MCLE in other states, please contact NIWAP at that email address, and they can work with you to try to get MCLE credit for other states.
Yes, and Carla, this is Leslie again. Our web library is niwaplibrary.wcl.american.edu, and we'll distribute that information with the materials as well.
Okay, great. So let's go ahead and get started with the webinar. Our goals today are to provide an overview of the rights of immigrants to access federally assisted housing, as well as to access federally funded emergency shelter and transitional housing programs. We are also going to identify and discuss issues that are specific to survivors of domestic violence, dating violence, sexual assault, stalking, and human trafficking. We're going to start with a poll to see who is in the audience today. So we have a question for you. Are you an advocate that works with survivors, an attorney that works with survivors, a shelter or transitional housing provider, or a public housing authority or other permanent housing provider, or government agency staff? And if none of these categories apply to you, feel free to let us know who you are in the questions chat box. Okay, we can go ahead and close the poll, please.
It looks like 49% are advocates who work with survivors, another 30% are attorneys, shelter workers, PHA housing providers, and government agency staff.
So it looks like almost half of you work with survivors, which is great, and I see there are also a couple of responses coming in the chat box, which also indicate that you work with survivors in some capacity directly. And then a good number of you are attorneys, work with survivors, and then there are some folks who, about 10% is shelter transitional housing. So it looks like a lot of the information we're discussing today in terms of the housing rights of survivors, immigrant survivors, will be very helpful to most of you all. All right, we're going to start by talking about Section 214 restrictions. So what is Section 214 of the Housing and Community Development Act of 1980? Some of you may have heard of this term, Section 214, Section 214 immigration restrictions, or just Section 214 restrictions. So what is Section 214? So Section 214 of the Housing and Community Development Act is a law that says that only U.S. citizens and certain categories of immigrants are eligible for the majority of HUD's programs. This is the U.S. Department of Housing and Urban Development. The immigration restrictions for these programs are found at 214. And so we have a quick poll for you, for those of you who may have heard of Section 214 restrictions. What program do you think is not subject to 214? So what program do you think does not have any Section 214 immigration restrictions? Okay, we can go ahead and close the poll. All right, this is very interesting. So half of you, about half of you, think that the Section 514 and 516 farm labor housing programs are not subject to 214 restrictions. And then the next more popular one is the low-income housing tax credit, and then public housing and Section 8 vouchers. So the answer is low-income housing tax credit program. That might be a surprise to many of you, but the LIHTC program, the Low-Income Housing Tax Credit Program, LIHTC for short, is not subject to any Section 214 restrictions. Section 214 applies to all of these programs that I'm pulling up here. It applies to public housing, the Housing Choice Voucher Program. So this is the program that has a tenant-based subsidy, where if a tenant has a voucher, they can use a voucher and take it elsewhere if the tenant moves with them. So for example, if I received a voucher in Sacramento and I want to move to Boston, Massachusetts, I can use that voucher in Boston, Massachusetts, as long as the Boston Housing Authority will take the voucher. Another program that is covered by Section 214 is a Section 8 project-based housing program. Just a clarification, because it seems like there's quite a bit of confusion about what is project-based Section 8. It's actually not a single program, even though it sort of sounds like it is. It's an umbrella term for a series of Section 8 assistance that is project-based, meaning that the subsidy is stuck to the unit and it does not travel with the tenant when the tenant moves. Some examples of what project-based Section 8 can be include the Section 8 new construction program and the Section 8 substantial rehab. So I just want to clarify that even though the project-based Section 8 program is sort of talked about in a way that make it seem like it's one program, it's actually an umbrella term for a series of programs. We also have the Section 236 program. This is the program where HUD subsidizes interest payments on mortgages for housing rented to low-income tenants, and the rent levels are regulated. There's also the Section 235 home ownership housing program, the rent supplement program, the housing development grants program, and only the low-income units that are funded by the housing development grants programs are covered by Section 214. And then you also have Section 23 leased housing program. And this program was the first housing authority administered housing program to use privately owned housing. It's essentially a legacy program at this point. It's the Section 8 existing housing program actually replaced the Section 23 program in 1974, but there are a couple of Section 23 units out there that have yet to convert to Section 8 yet. And Gideon is going to explain to you the Section 214 restricted rural development programs.
Good morning or afternoon to everyone. For those of you who are not familiar, rural development is part of the United States Department of Agriculture. It operates in rural areas, and typically it works in cities or towns, but not exclusively, with a population of less than 20,000 people that are outside metropolitan areas. The 514-516 Farm Labor Housing Program is a loan and grant program that makes funding available for the construction of farm labor housing. It's produced probably only about 36,000 units. It is restricted by statute to citizens and permanent residents, and RD has taken the position that Section 214, which allows people to live who are outside the citizen and LPR categories, allows others to live in restricted programs, but RD has taken the position that the 514-516 statutory requirements are more restrictive, and therefore it continues to limit the program to citizens and permanent residents. The other program that's restricted is a Section 502 direct home loan program, where RD makes direct home loans to residents in rural areas for the construction or purchase of single-family homes. The Section 504 Rehabilitation Loan and Grant Program is a limited program which makes small amounts of money available for the rehabilitation of properties owned by the recipients of the grants. And probably the largest program that's covered is a Section 521 Rental Assistance Program, which is used in both the RD Section 515 Rental Housing Program and the Section 514 and 516 Farm Labor Housing Program. And I'll get into that a little more later. The RD Voucher Program is the last program that is restricted by Section 214. It is a restricted voucher program which is only available to residents of Section 515 housing whose owners prepay their loans, and the voucher program is intended to protect those residents against displacement.
Thanks so much, Gideon. So we just went over all of the programs that are subject to Section 214 restrictions, but what programs are not subject to Section 214's immigration restrictions? There are a lot of programs. This list is a very long list, but it's actually not a comprehensive list of the housing programs that are not subject to Section 214. But I'll just sort of quickly run through this list with you. So we have the Low-Income Housing Tax Credit Program, which is a program that is administered by Treasury and the IRS. We have HUD Section 202, Housing for the Elderly, Section 811, Housing for the Disabled, Section 221D3, which is a mortgage insurance program provided by HUD to owners, Indian Housing Community Development Block Grant, the Home Program, Housing Opportunity for People with AIDS or HIV, and the McKinney-Vento/HERF Act program. There is an asterisk next to the McKinney programs because within one of the programs that is a McKinney program, so there's the Emergency Solutions Grant Program, and there's also Continuum of Care. Many of you may have heard of continuums of care. You might actually be also working directly, or you're part of a COC in your jurisdiction. But within the Continuum of Care program, there is a housing program called Section 8 Moderate Rehabilitation Single Room Occupancy Program, or Section 8 Mod Rehab SRO program. And this program actually receives Section 8 assistance directly, and because, like we said before, Section 8 and project-based Section 8, because those are subject to Section 214 restrictions, that particular program within the COC program, Section 8 Mod Rehab SRO, that is also subject to Section 214 restrictions. We also have rental rehabilitation, HOPE 2, which is a home ownership program, and a couple, and then Gideon's going to walk us through the last two, which are RD programs.
The Section 515 Rural Rental Housing Program is the rental program that RD runs in rural areas, and the 515 program without rental assistance is not restricted by Section 214. I should point out that even units with rental assistance are currently not restricted by Section 214, because in 2004 we challenged rural development for the regulations it implemented trying to restrict housing with rental assistance, and as a result of challenge, the agency published regulations which state that even people who are receiving rental assistance are currently eligible for rental assistance even if they're non-citizens and non-LPRs. The regulation is actually seen as a note in 7 CFR Section 3560.152. I am afraid, frankly, because the RD regulations which are published by the agency do not have this note, my guess is that most owners of 515 rural rental housing are in fact enforcing Section 214 in the 515 housing. My guess is that those should be or my recommendation is those should be challenged, because the regulations clearly exempt Section 214 from implementation within rental assistance units. The rental housing preservation grants are a very small number of programs of grants that are made to nonprofit organizations in rural areas and helps them preserve single-family and multifamily housing in rural areas. The Section 538 Multifamily Loan Guarantee Program is another rental program which is operated by RD, but the loans themselves are not made by the agency. In fact, they're only insured by the agency. As a result, the Section 538 program is not covered by Section 214.
Thanks a lot, Gideon. I'm going to make a note here about mixed financing. If the housing that's at issue has mixed financing or layers of subsidies involved, and there's both a mix of 214 and non-214 subsidies, then what happens is that Section 214 immigration restrictions apply. So a really good example of this is project-based Section 8, which is often used in mixed financing. If that is combined with, for example, LIHTC.
I can hear you.
No, we're fine. Okay, sorry about that. We're having some tech issues. But if we're in a situation where there's project-based Section 8 and say there's low-income housing tax credit and project-based Section 8 together, then because the project-based Section 8 is there, the Section 214 restrictions apply. Same with Section 202 or 811, even those two programs are not 214 restricted. If you combine it with, say, project-based Section 8 or some other subsidy that has the 214 restrictions, 214 restrictions apply.
Great. So I'm Leslie Orloff. I direct the National Immigrant Women's Advocacy Project, and I'm going to kind of pick up the slides for a little while from here. I see there are a lot of questions coming in the chat box. Hopefully many of these things will get answered as we go forward today, and anything left at the end, we will review the chats and make sure we get back to you with answers. Just starting with a poll. So Carla was talking about the restrictions on Section 214 housing. As of today, which of these groups of immigrants or immigrant survivors are not eligible for 214 housing? One group on this list is not eligible. Which one do you think it is? We'll take a second while people are filling out the poll. Has everybody gotten a chance to vote? Can you show us the results? Okay, so it looks like about a third of you have chosen U visa recipients or applicants. The next choice was asylum recipients, then VAWA, then Ts, and VAWA self-petitioners and lawful permanent residents. So the third of you that chose U visas, that is correct. As of right now, oops, okay, can you show me the poll back again? Francis is great. So what's interesting is the point I want to make, we did some research, and I'm going to be showing you that in a few moments, in the field to see what was happening in terms of victims being able to get access to housing. And there's a lot of confusion and information out in who's available for what out there. And just to confirm, and that's why I think this webinar is so important, VAWA self-petitioners, in fact, are eligible for Section 214 housing. Asylum recipients and trafficking victims are and have been for a very long time, and so are lawful permanent residents. So it's U visa recipients on this group that are not. Next slide, please. So when we look at, and when we're talking about immigrant survivors, in addition to the VAWA self-petitioners, who I'll be talking about in much more detail in a few minutes, there's a range of victims of domestic violence, sexual assault, human trafficking that will also fall into stalking, dating violence, will also fall into some of these other categories. So the full list of who's eligible for Section 214 includes lawful permanent residents, citizens, VAWA self-petitioners, refugees and asylees, trafficking victims, parolees, and a variety of other groups. But most of the people that you'll see that you'll work with are going to fit within the categories, I guess you could say, that are from trafficking and above on this list. Next slide. U visa holders are not eligible for Section 214 housing. And so it's important, one of the things that we're going to be distributing after the webinar is a screening tool, a new screening tool that was issued by DHS that helps people screen the difference between a U visa and a VAWA, somebody who might be eligible for trafficking, SGIS, and other special immigrant juvenile status and other remedies. And it's really important because one of the things we're hearing from people at USCIS, and we're seeing it in the field as well, is that we're running into a lot of cases in which people who are actually eligible for VAWA self-petitioning are filing for U visas instead. So people are not getting screened correctly for VAWA self-petitioning. And here in the housing area, there's a tremendous difference. Filing a VAWA self-petition makes you eligible for public and assisted housing. Filing a U visa does not. And so in addition to the long wait lists that are come along with the U visa, and VAWA self-petitioning wait lists being much shorter, it's important to sort out the victims whose perpetrators are their U.S. citizen or lawful permanent resident spouses or parents or step-parents, so that they can pursue the right avenue of relief. And that, again, trafficking victims in particular are also explicitly eligible for housing benefits as well. Next slide, please. So VAWA self-petitioners are eligible for federal public benefits. This has been true since 1996 welfare reforms, and that they continue to be eligible. It took many years for Congress to confirm that DHS and HUD were supposed to work together to make access by VAWA self-petitioners really happen. Although as a matter of law, it was available and continues to be available today. And what has happened is that there have been changes made. Next slide, please. In the SAVE system, which I'll talk about in a moment, that make it easier now for VAWA self-petitioners to have a satisfactory immigration status, and to actually, the system at DHS now for verification actually works to verify status of VAWA self-petitioners. And I'll explain exactly how that system works and how public housing authorities and advocates and attorneys working with victims can advise public housing authorities to complete the verification in these cases, so that VAWA self-petitioners not only will be initially eligible, but can continue to be eligible for public and assisted housing. There have been, there's a legal memorandum from HUD as to this in your materials, and a notice from the Public and Indian Housing on how to use the SAVE system to verify cases of VAWA self-petitioners. Next slide, please. So let me start first by saying when we use the term VAWA self-petitioners for purposes of eligibility for housing, for public and assisted housing under Section 214 and all of the Section 214 programs that Carla was discussing, this is the list of people we're talking about, so I'm going to go over them. Victims, so what we traditionally think of VAWA self-petitioners, somebody who has filed what's called a VAWA self-petition. The form is the I-360, and it includes the victim and her children who are both eligible upon filing. You don't have to wait till prima facie determination for housing benefits. It also includes people who filed VAWA cancellation, removal, or suspension of deportation applicants. In these cases, the victims' children are not included because, as a matter of immigration law, they're not included within, they can't be included in the applications for suspension of deportation or cancellation of removal. And so, but generally speaking, as a practical matter, because the VAWA cancellation and suspension cases emanate from the immigration courts, as a practical matter, they only hit the SAVE system once the victim receives work authorization. The work authorization will then get into the SAVE system, which will show up when the public housing authorities do a search. The other group that people often forget about when they're thinking, that is also covered by VAWA self-petitioner definition, both in the 1996 legislation and in these policies in terms of VAWA self-petitioners and HUD, are people that where their perpetrator, spouse, or parent filed an I-130 visa application for the victim of abuse. That application has been approved, but the victim and the victim is proceeding under that approved application to get lawful permanent residency, or they have that application pending and it's been approved. The approval will show up in the SAVE system as well, and those people, if they're subject to battering or extreme cruelty by the abusive spouse or parent who filed for them, will also be eligible for public and assisted housing benefits. And I'll explain a little bit more about how those cases differ from the I-360 VAWA self-petitioners in a few moments. Next slide, please. So what happens is if you're advocating or you're working with a victim who's got, let's take a pending VAWA self-petition. What you will do is bring to the housing authority information. You're going to bring, among other things, a copy of whatever piece of paper you have from the Department of Homeland Security verifying that she's filed her VAWA application. So it could be a receipt notice, it could be a prima facie determination, it could be approval notice, essentially anything that has her immigration case number on it, which is her A number. And what you do is that the housing provider, either the landlord or the public housing authority, the housing provider, will go into the SAVE system and enter the information, her name, her date of birth, and the information about her immigration case into the system. And that what will happen is because of something called VAWA confidentiality, the system, if she has not yet received work authorization, the case will kick it back as no, it'll be a no match. And then there's a screen that will come up where the housing provider will go in and say, check off a box or click saying institute additional verification. And then they will complete that form, and then DHS will conduct a manual verification of the existence of the VAWA self-petition or the I-130 approved case, and get back and verify to HUD that that person is eligible, that, you know, if there's a match in the SAVE system. That's essentially how it works. VAWA confidentiality continues to be statutory and enforced in effect today. It's just particularly important that VAWA self-petition, that you screen early for people who are eligible for VAWA self-petitioning so that they can get their case filed and will have the evidence they need, whether it's a housing case or otherwise, to have a case on record as a VAWA self-petitioner. Next slide, please. So you're going to, as I said, you're going to enter the name and the A number and the date of birth. It'll come back either match or no match. If she's got a work authorization, if she's reached the stage of work authorization in the case, it'll be a match. If not, it's a no match. They click Institute Additional Verification, and then they type in Verify VAWA Self-Petition, if it's an I-360, if it's a VAWA Self-Petition, or Verify I-130 Visa Petition, if it's one of the cases where it's an abused spouse whose perpetrator has filed for them. And then just like we do when we're uploading our flex plans or information to a bank or whatever, they're literally going to, and this is why we have all of this now, because there's a way now to upload documents and doing verification using computers that we couldn't do effectively with fax machines back in the day. And so you're going to upload a copy of the VAWA self-petition or the notice of action or the receipt notice or the family-based visa petition, and with that information, DHS will do a manual verify. Next slide, please. So the DHS response will come in the vast majority of cases. It'll come back in 3 to 5 days. If there's any complication in the case, it'll come back in no longer than a month. The DHS will, if it's a VAWA self-petitioning I-130 case, 360 case, DHS will confirm that it's a VAWA self-petitioner, and that is the end of the story. The victim will be immediately eligible for housing, and no evidence of battery or extreme cruelty according to the policies can or shall be requested or collected from the victim, because it is a DHS adjudication about whether or not she's been abused is a DHS adjudication, not a HUD adjudication. So once she's filed, if it comes back and she's filed the case, her eligibility will get determined in the VAWA self-petitioning case. If she's denied her VAWA self-petition, let's say, or he or she's denied the VAWA self-petition, when HUD comes back for additional verification, there'll be a no match again, and they won't continue to be eligible for housing. But if it's granted, they will continue to be eligible for housing from the moment of filing until they obtain lawful permanent residency. Next slide, please. In the cases where the abusive husband, wife, or father or mother filed the VAWA self-petition, or the family-based visa application, and the person applying for housing is the abused child, under 21-year-old child, or is the abused spouse of the person who's filed the I-130 visa petition, these are cases where if they're approved, they'll come back as a match in the hand verification system, but then as advocates and attorneys, it's going to be your responsibility to provide evidence to HUD, or to not to HUD, to the housing provider, who will then need to independently, in order to continue to receive housing, once they have the match, they're going to have to show that they are victims of battering or extreme cruelty. The HUD policies and legal opinion follow the definition of battering and extreme cruelty adopted in the immigration cases, and the site is on the screen. And so that there's a two-step process if it's a person with a visa application trying to stay in or get the housing subsidy, and they'll have to prove battering and extreme cruelty. Next slide, please. Oops. One back. There we go. This is the Department of Homeland Security's definition of battering or extreme cruelty. In the materials and on our website, we have lots of materials on how you prove battering or extreme cruelty. And as you'll see, it is not limited to acts of physical violence. It includes both psychological and sexual abuse that raise to the level of extreme cruelty, often includes evidence of coercive control, and we have lots of materials available to you from the immigration context that you can use in the housing context to prove battering or extreme cruelty. Next slide, please. So some of the evidence that you can, and using the any credible evidence standard, the housing providers, like the Department of Homeland Security adjudicators, and like, I believe this has come up in the context of TANF, for not related to immigrants necessarily, but the idea of how you prove using any credible evidence standard. Again, that's something that if you want more detail, we have whole law review articles on, and legislative history, et cetera, and training tools and materials at our website. But basically, it's the affidavit or statement from the victim, medical records, photographs of injuries. Just as in the VAWA self-petitioning context at DHS, the police reports, protection orders, criminal court, family court records are helpful but not required. So housing providers shouldn't be mandating any particular piece of evidence. And the reason for that is that the any credible evidence standard recognizes that there are dangers involved from the perpetrator who controls evidence, and we didn't want to force victims to go back to perpetrators to get evidence in order to qualify for housing or obtain immigration relief. But the housing provider, just like DHS in the VAWA self-petitioning cases, victim can prove eligibility and the fact of the battering, extreme cruelty using any evidence that they can muster, but the ultimate determination on credibility rests with the housing provider as to whether they've proven that they were a victim and are eligible, because it requires the verification of the I-360, I-130 approval, the family-based visa petition approval, plus evidence of a battering or extreme cruelty to qualify to continue to get the subsidy under the I-130 cases. Next slide, please. So VAWA's housing protections apply. So is this
Leslie,
my
I think it's over.
It's yours.
Thanks, Leslie. So we're going to talk very, very briefly about the Violence Against Women Act and the housing provisions. The NHLP is actually going to be conducting another webinar next Wednesday at the same time, 11 a.m. Pacific time, 2 p.m. Eastern time, where we're going to talk about VAWA's housing provisions in detail, and specifically about HUD's rule implementing VAWA 2013, which was issued last November and is effective December 16th. So I'm not going to go into any kind of detail here, but I just want to clarify, because I understand there's a lot of confusion about whether or not VAWA applies to immigrant survivors. So VAWA's housing protections apply to all survivors regardless of their immigration status. Where the confusion probably comes up is there are these VAWA protections, but then there's also eligibility issues related to the program. And my apologies, there seems to be an ambulance going by right now. But VAWA's housing protections does not supersede any kind of housing program eligibility requirement. So for example, a survivor cannot be discriminated against for having experienced a VAWA crime like domestic violence. And so that person should be able to apply for a public housing or Section 8 voucher program. However, if that person does not have the right income or does not have the prerequisite immigration status necessary in order to actually be eligible for those programs, that person will not actually be able to get the housing. They would not be able to participate in the program. And just one final note about lease bifurcation under VAWA. So lease bifurcation, just very quickly, is the ability for a housing provider to split a lease such that the abuser is kicked off of the lease or kicked out of the unit, and then the survivor is able to remain in the unit, as well as any other roommates or dependents who may be on the lease or on the housing assistance. We'll go over this in detail on next week's VAWA webinar, but very quickly, lease bifurcation rights under VAWA, whoever remains after lease bifurcation happens, so that would be the survivor and roommates or dependents, those folks who remain have certain specific rights, including the ability, if they didn't already establish eligibility for the existing program that they're getting assistance under, they have the opportunity to establish eligibility for the program. And if for some reason they don't qualify for the program, they have the ability to find alternative housing or to try to establish eligibility for another program. We're going to talk a bit about mixed status families. So to qualify for admission to HUD Section 214 housing, and I emphasize HUD because the idea of proration is not necessarily recognized by RD, and Gideon will get into the details of that. But to qualify for admission to HUD Section 214 housing, at least one household member must be a citizen or fall into one of the immigrant categories that Leslie mentioned before. The eligible household member can be a minor child, and the ineligible family member can still live in the assisted unit. But what happens if there's a mixed family is that proration of the assistance must happen. And so this is sort of a step-by-step guide as to how you would actually calculate one's prorated subsidy. If not all members are eligible, the housing assistance is prorated to reflect the presence of ineligible immigrants. Generally speaking, the household assistance will be reduced based on the ratio of ineligible household members to the total number of household members. Honestly, I learn better through examples. So on this slide, we provided an example of the Smith family. We have Jane Smith here, who is a U visa holder. She lives with her two minor sons who are both U.S. citizens. They would like to get a Section 8 housing choice voucher, and so they've applied for one as a family with their local housing authority. So Jane is a U visa holder. She, like we talked about before with U visa holder, she herself is not an eligible immigrant under Section 214 restrictions. So she's applying for a Section 214 program, the voucher program. She's not eligible. But she has two minor sons who are both U.S. citizens who are both eligible. And because they are both eligible, they can apply for a housing choice voucher. So let's say that in their jurisdiction for a two-bedroom unit, the voucher amount, a housing authority will pay $1,300 in rental subsidy to a private landlord. You create a fraction where you have the number of folks on top who are eligible for the assistance, and then the total household members on the bottom. So you have 2/3 here, the two meaning the minor sons, and then 3 is the total number of all the folks in the household. So the subsidy is then essentially is decreased by the number of folks who are not eligible for the assistance. So 2/3 times 1,300 equals $867. So effectively, the subsidy has gone down from $1,300 to $867. And so what is the amount of rent that the family has to pay? So let's assume for this purpose that the rent for the unit is $1,300. So it's $1,300 minus the subsidy, so it's $433, and that's the amount that the family has to pay out of pocket because of the proration. A note about other eligibility. Some state and local governments have supplemental subsidies that can be used along with the federal housing assistance and also have no immigration restrictions. And so if you are looking to sort of fill a gap in a situation where there's prorated subsidy, or you're just looking for other kinds of subsidies that may not have immigration restrictions, then I would encourage folks to look at their local state and local governments, see if they offer anything. Okay, so non-citizens who claim eligible immigrant status in Section 214 programs are required to submit documentation of their status. A really important note is that housing assistance cannot be delayed pending any kind of final determination by USCIS of the applicant's status. So if the applicant has provided the requisite information to the owner or housing provider and their name reaches to the top of the waiting list before USCIS can complete the immigration verification process, the applicant must be offered the housing assistance. Also, once the documentation is verified for one member of an applicant household, the household cannot be denied admission just because the full verification for the entire family, for all of the household members, have not been determined yet. Their eligibility in terms of their immigration status have not been determined yet. So if you're facing a situation where essentially the applicant is facing denial because of immigration status, there are some due process rights that they have. An applicant must be notified of the right to appeal the lack of verification. The applicant can pursue an appeal through either the housing authority or the owner. or through USCIS. They don't have to do both. They don't have to do both the PHA/owner and USCIS. To appeal to the USCIS, the appeal has to be made in writing within 30 days of the rejection. The applicant has a right to a hearing before an impartial individual. And within 14 days of the hearing with the Housing Authority, the applicant must be given a written decision. And Gideon is going to walk us through the RD challenging of denials. Oh, Gideon, we can't hear you. You might be on mute.
Hold on just a second.
We can hear you.
Now we hear you.
Okay, it seems like Gideon's having some technical difficulties. So basically, this slide shows us how different role development is. So first off, role development has not adopted the proration formula. Proration as a concept is a Gideon?
You hear me now? Yeah.
Yes. Go ahead.
Sorry. My apologies. I had to switch modes and that caused some problems. Anyway, you're right. RD has not adopted the proration formula for any of its programs, and that does not make sense. And it simply displays the fact that RD has just simply not understood Section 214 and has not implemented it properly for any of its programs. So, fortunately, in a single-family homeownership program, the 502 program, it only requires one person in a household to be eligible for the loan, and therefore the proration formula really doesn't apply at all the way they have done it. But in a 515 program, the rental housing program, it has not adopted the proration formula. It has not allowed minors to qualify the entire household. And in fact, it's done the very opposite in the sense that it requires all household members to be Section 214 eligible. Fortunately, as I said earlier, the agency has postponed implementation of these restrictions, but it has done so only if you look at 7 CFR Section 3560.152. There is a note to that provision which says that the citizenship requirement has been postponed and it's not been implemented since 2004. RD also has no method for appealing denials of assistance due to the status of an individual. So practically every decision that someone makes on behalf of Section 214 eligible borrowers or eligible tenants can and should be challenged.
Thanks, Gideon. We have someone online who is asking what RD is. Can you just quickly tell us again what RD stands for?
Sure. RD stands for Rural Development. It's a part of the U.S. Department of Agriculture. It operates programs, housing programs in rural areas. What most people don't know is that probably with its guaranteed loan programs, it operates about $24 billion worth of rural housing programs. Most of them are the multifamily guaranteed loan program, but it also has a rental housing program and a single-family homeownership program. RD operates generally, but not exclusively, in towns and cities under 20,000 in population outside metropolitan statistical areas.
Thanks, Gideon. We're going to talk about documentation and verification. Social Security numbers, we get quite a few questions about Social Security numbers and when they're required and when they're not. The Social Security number requirements are subject to HUD rules. For most of the HUD programs, every member of an applicant household must disclose their Social Security numbers to be eligible for assistance. This requirement applies to the public housing program, any of the Section 8 programs, Section 202, supportive housing for the elderly. Section 811, supportive housing for the disabled. And then a number of programs that you can find in those subparts, but it includes 221D3, which is a mortgage subsidy interest rate program, and 236 as well. And then also a few homeownership assistance programs. In terms of the requirements, to verify Social Security numbers, an applicant must produce, and this is true for the public housing and Section 8 Housing Choice Vouchers program, an original Social Security number card, an original SSA issued document containing the applicant's name and Social Security number, or an original document issued by a federal, state, or local government agency containing the applicant's name and the Social Security number. The requirements are slightly different for HUD multifamily. So multifamily is the division within HUD that administers the project-based Section 8 program, the Section 236, 221D3, et cetera. And so they require a Social Security number card or a number of other documents, which include a driver's license with a Social Security number, payroll stubs, bank statements, Form 1099, even a retirement benefit letter. There are quite a few options. The housing provider then transmits the applicant's name, Social Security number, and date of birth to HUD, and then HUD validates the Social Security number against the administration's database. The Social Security number disclosure requirement does not apply to applicants who do not contend eligible immigration status. So in the example of mixed status families where perhaps some folks are eligible and some folks are not eligible based on immigration status, the folks who are not eligible do not have to disclose any kind of Social Security number. A housing provider cannot deny assistance to mixed families due to non-disclosure of a Social Security number by an individual who does not contend eligible status.
The rural development does not have authority to collect Social Security numbers from applicants to its rural rental housing program. Notwithstanding, its regulations insist that landlords collect Social Security numbers from their residents. Because it does not have the authority, RD has a Form 3560-8, which is a tenant certification form which every resident must complete both upon entry into development as well as annually thereafter. It states in the right-hand top corner that RD will not deny eligibility to applicants who refuse to disclose their Social Security number. I have no idea to what extent that is being enforced or to what extent applicants, particularly those with limited English proficiency, are being advised that they will not be denied admission to or assistance under the 515 or other programs if they do not supply their Social Security number. And advocacy will probably have to be used to challenge RD when they demand Social Security numbers from applicants, which is, as I mentioned, illegal.
All right, in what circumstances does a housing provider have to report someone's immigration status to ICE? So the only requirement that a housing provider has is in the situations of housing authorities. So a housing authority that quote-unquote knows that someone contending eligibility for Section 8, and this is Housing Choice Voucher Section 8, or public housing programs in the country, that is in the country illegally, must report that information to USDA on a quarterly basis. So this only applies to housing authorities. It does not apply to private landlords. And so what does it mean to know whether or not someone knows about someone's illegal immigration status? So it has a very narrow definition, and this term know is defined in a joint notice that was issued in 2000 by a number of agencies, including SSA, HHS, DOL, HUD, and the former INS. And what no means is a finding of fact. There has to be a finding of fact or conclusion of law made by the housing authority as part of a formal determination that is subject to an administrative review on the applicant's claim. And in addition to having that finding of fact or conclusion of law, there also has to be a finding that is supported by a determination by USCIS or the Executive Office of Immigration Review, such as a final order of deportation or removal. So this is really important because it is a very, very narrow definition. The reporting is not triggered by an oral or written admission by the immigrant. It is not triggered by a worker's suspicion, assumption, or firm conviction about the person's immigration status. It is not triggered by a response from USDA to a SAVE inquiry that fails to confirm an applicant's immigration status or that shows an immigrant status that would make the applicant ineligible. And it is not triggered by a formal finding that the person is ineligible for a benefit. And now Leslie is going to talk about emergency shelter and transitional housing. Leslie, are you on mute?
Yes, thank you. Next slide, we're going to start with a poll. So have you worked with an immigrant survivor who was turned away from transitional housing? Just take a second, a minute or so, and click yes, no, or not applicable. Francis, can you show us the results? Okay, so 22% of you report having worked with an immigrant survivor turned away from transitional housing. I guess in the text box or the question box, can you tell us what survivor? Domestic violence, sexual assault, human trafficking, stalking, dating violence? It would be nice to get a picture of that. While I'll go forward and then I'll pick that up as we go. But were they, and also I guess in the chat box, what were they being required to provide? Can we take a second? And I guess it's the questions box that you're putting it in. Is that correct, Carlo?
That's right. And there are a lot of responses coming in. There are a lot of folks reporting domestic violence survivors, a couple of trafficking, a DV survivor turned away from transitional housing. The program would only take one applicant. Oh, some have required Social Security numbers.
Okay.
Another Social Security number. Undocumented victims of domestic violence, more Social Security number requirements. Yeah, a whole bunch of driver's license requirements. Yeah.
Okay, great. Not great actually, but next slide.
Mm-hmm.
Next slide, please. Oops, I'm not seeing it. Great. So, I didn't mean great. I mean, what you're reporting is more or less, NIWAP did a national survey to get a sense of what was happening in the field regarding access to shelters and transitional housing. And a lot of, the people reporting to us look very much like the groups of people on this webinar. 26% work in government agencies, victim advocates, legal services providers, etc. And of that, when we looked just at transitional housing, we got reports on about 9,000 cases. And what we found, next slide please, was that by the vast majority of time, sexual assault survivors were being turned away almost no matter what, at significantly higher rates than anyone else, and not able to access transitional housing. What we also found is much of what you reported just now when you were filling out the chat, the question and the poll, is that victims were being turned away based on immigration status, even though both shelter and emergency shelter and transitional housing programs have since 2001 and before, but policies have been in place for, I mean, over a decade and, a decade and a half, that people were immigrant survivors are supposed to be able to access these programs without regard to immigration status, but as you can see from the findings, In 84% of the cases, the people were requiring immigration documentation. Almost half of them driver's licenses. They have legal work authorization, which you couldn't have without immigration. All of these issues were what people were running into. Next slide, please. So we also looked at this from these 9,000 cases that were reported, getting a sense of who was being accepted. And that here too, you see the pattern that, first of all, what's interesting about this is these are the major categories of crime victims that have historically been eligible for transitional housing but being turned away. Trafficking victims who have like the best, most ironclad, strongest legal access protections were even being turned away, were also being turned away at a 20% level. Domestic violence victims more than half, and sexual assault victims, as well as abused, abandoned, and runaway children. All of those were covered by the 2001 memo. Next slide, please. And so for transitional housing programs that are necessary to protect life and safety, and for emergency shelter programs, undocumented immigrant survivors have a legal right to access the program, both shelter and transitional housing, without regard to immigration status, citizenship, nationality, or language ability. Next slide, please. And that there's a range of benefits and services available to anyone without regard to immigration status, because those programs are deemed, have been deemed for years to be open to everyone because they're necessary to protect health and safety. And there are policies that have been issued by DOJ, HUD, and HHS confirming that they apply to domestic violence victims, sexual assault victims, stalking, dating violence, human trafficking, child abuse, some other forms of abuse, the homeless, runaway and homeless youth, and abandoned children. And that's the realm of people that these programs are open to. Next slide, please. And that essentially that these are open because they're considered in-kind services provided at the community level, not based on the individual's income or resources, that are necessary to protect life and safety. And that it's the Attorney General in the immigration reforms and welfare reforms of '96 was delegated to the Attorney General to determine what kinds of programs were open to everybody without regard to the immigration status, because they were necessary to protect life and safety. And that's how these transitional housing programs have been always open to these groups of survivors, and are absolutely open now. And we have all of the federal government documents and materials and everything you need, regulations and policies, to show a transitional housing program that might be turning a victim away or asking for immigration status information or information or documentation, like a work authorization that would be related to immigration status, for documents that the victim may not have. Next slide, please. So HUD stated, as I said, in 2001 that emergency shelter and transitional housing are deemed to be necessary to protect life and safety, and that housing by its nature is short-term and a bridge toward permanent housing. Next slide. And so in your materials, you have the joint letter from HUD, DOJ, and HHS confirming and restating as explicitly and more explicitly the policy from 2001 that has been in place throughout every administration since then. And that this joint letter says that people that are receiving funding from any of these agencies, so, you know, HUD, OVW, OJP, OVC, Office of Victims of Crime, HHS, Family Violence Prevention and Services Act, any of those grantees must not turn away individuals based on immigration status for programs and services and assistance necessary to protect life and safety. And so it includes short-term shelter or housing, transitional housing. It also includes crisis counseling and intervention, medical and public health services necessary to protect life and safety. And there's a long list. We have a brochure that we can distribute to you with the materials that summarizes these eligibilities. Next slide, please. So from a HUD perspective, as Carla was discussing earlier, this includes the emergency solutions grants, community of care grants, have no immigration restrictions, street outreach services, emergency shelter, safe haven, rapid rehousing, transitional housing programs that meet the in-kind and community level necessary to protect life and safety tests have no immigration restriction. The only ones that do were those where the rental assistance is made for a participant because the regulations issued by HUD require an income test. And so the materials, again, the statements by HUD confirming all this are in the materials that we'll be distributing. Next slide, please. So what this means is that there's an opportunity here for really good victim advocacy. The government, okay, and this applies, as I said earlier, to government-funded programs funded by VAWA, FIPSA, the Victims of Crime Act, and HUD, all of them. Next slide, please. Okay, I think we skipped one. Did we skip one? There we go. So this is an opportunity, as I said, for really good victim advocacy. And what we found is in doing, looking at the research we did and looking at kind of what transitional housing programs are doing nationally, what we're finding is that many of them are imposing requirements that are not federally required. Basically, that the funders are not requiring. They might be imposing, that a victim has to prove a path to self-sufficiency. Some places might be imposing some kind of a jurisdictional residence requirement. Some places might require that they show a risk of homelessness. Programs often will require a lack of active substance abuse or a lack of a criminal history. But what's interesting here is that the path to self-sufficiency, which is imposed by some programs, many immigrant survivors can meet because they do, in fact, have some form of income either from work or from child support or from family support or other means. And so what I'm going to move on to is talk about how you can help survivors meet these eligibility requirements that are imposed by some programs so that they can gain access, so more victims can gain access. And to understand that if you look at the Office of Violence Against Women has some very good materials that have been produced by the National Network to End Domestic Violence on what programs requirements should be for domestic violence survivors, and they're not around self-sufficiency necessarily. They're much more around victimization and being involved in moving on a path towards healing and program requirements like that. But rather than just kind of have victims give up when they can actually prove, immigrant victims can prove self-sufficiency, I want to walk you through some ways to do that. Next slide, please. So some of the examples, residency can be fairly easy. This is evidence of residency like in the family law case or like in the local state law cases. Are they physically present? It's not lawful permanent residence, not immigration status residence. It's about where they live. And so you could prove that with a victim statement, postmarked mail that may come to the residence in the jurisdiction. There may be school records for the children or health records that report the address, or if she filed for a protection order, there might be court records. Copies of police reports of incidents occurring in the jurisdiction against the victim would be another way to prove residency, and then letters of neighbors and shelter victim advocates, etc. And then we have, again, in the materials, a brochure that gives you a checklist of some of the things you can do. Next slide, please. So evidence of victimization or homelessness. Again, many of you are working with victims know how to prove victimization. Or statement is one way, police reports, medical records, court records. A VAWA or U visa application The fact that she's filed one or some of the evidence included in one could be provided. Just a note, and what's important to note is that if you're providing, you have to be concerned about VAWA confidentiality, meaning that the housing provider to whom you show these materials to prove the evidence, eligibility, shouldn't be distributing that info, should be keeping it confidential and not be distributing it, but you need to think about safety and confidentiality when you're giving people copies, like the Transitional Housing Program, for example, copies of a VAWA Self-Petitioner or U-Visa. The same issue doesn't apply when you provide them to a housing provider for purposes of uploading them in the SAVE system, because under VAWA confidentiality law, the housing provider is bound by VAWA confidentiality and can't release that information if they receive it for public benefits verification purposes. So protection orders, photographs, and the like can be an evidence. If it's about homelessness, evidence of poor rental history or evictions, or that, you know, her abuser is in the house and she's fled the house, etc., might be some ways you can prove that. Next is the big one, and I think the most important one, which is evidence of self-sufficiency. When I do this live, I usually ask you to raise your hands, but, oh, is there a way for people to raise their hands, Carlo? And we can see it? I think I don't know. But
sorry, I think that's a question.
Pardon?
I think that's a question for Francis.
Anyway, when I do this live, I usually have people raise their hands, so just you can imagine that. I would bet, based on the trainings I do across the country, that many of you have worked with immigrant survivors who are in fact working and do in fact have income. And so if they do, then you can get creative about how you prove that income to meet a self-sufficiency requirement rather than fight the self-sufficiency requirement if you're working with an immigrant survivor who's actually employed. Some victims may have a tax ID number that they use to pay taxes when they work. You might be able, just like we did in family court, to get an employer statement or a letter with a letter from the employer that you might attach a photo of the victim, of the person who's applying, the victim, to show that that person belongs to, you know, that name. The way I used to prove documentation of income in the old days, back in the 80s when I worked at IUTA, I had clients who were working or paying cash, and I used to literally Xerox the money and circle the numbers on the bills, you know, the serial number on the bill, to show that there were different bills, and use that to prove that they had income. Child support payments, that she's receiving benefits for her citizen children that they're eligible for, could all be part of showing how she's going to put together a self-sufficiency package. But the one I get most excited about is that if you've screened the case and if she's filed a VAWA or U-Visa case, the fact that she's filed the case means she's on a path towards work authorization. It's a question of whether it'll take 7 months or 28 months. But if she has a pending case and that you've done your homework well that will be approved, she can use that as evidence of showing that she's on a path to self-sufficiency for transitional housing purposes. Also, things like taking ESL classes can show that she's doing things that will make her more viable in the workplace. Next question, or next slide, please. And then the next thing I want to talk about before we open this up to try to process and answer some of the questions you've been asking is it's really important that the policies that we've distributed to you in the materials from HUD and DOJ and HHS all confirm that there's a whole range of anti-discrimination provisions and protections that apply to cases of immigrant survivors in or seeking access to shelter, transitional housing, public assisted housing, and the other forms of housing as well. Carlo, back to you. Do you want to discuss more about the anti-discrimination, perhaps?
Sure. I think you basically covered it. There are a number of anti-discrimination laws that apply to survivors, immigrant survivors, and immigrants generally. Here are some of them. Title VI protects folks from being discriminated against based on race, color, national origin. The Fair Housing Act is a civil rights statute that protects folks from being discriminated against in the context of housing, and these are all the protected categories. VAWA as well provides a number of anti-discrimination protections, and then Section 109 under HUD as well. And if folks have questions about this, or they think that there might be some discrimination occurring against immigrants that are being targeted towards immigrants, feel free to contact us, and we'd be happy to kind of talk through the facts with you. Here are materials. All of these materials are in the information packet that was circulated to you. There have been a number of questions about whether or not the slides in the information packet will be circulated again. Yes, they will be to everyone who registered, so everyone on this call and other folks who are not able to join us live today will be getting those materials. And then we do have an upcoming webinar. Someone asked about the registration link for the VAWA webinar next week. There it is. It is at 2 o'clock Eastern Time, 11 o'clock Pacific, 1 o'clock Central. It'll be 90 minutes. We'll be doing some more marketing for it if you want a little bit more information. And then probably later on in the year, we'll be talking more about HUD authority that has come out the last 6 months of 2016 that impact the housing rights of survivors. And the date and time is to be decided on that. Here's
Can you go back, actually, Carla, one slide? I wanted to talk about the materials for a moment more. So just so you know, so you can see what's here, we've included we'll just explain a little bit about more what these are. There's the joint letter on DOJ, HHS, and HUD on access to shelter and transitional housing is included, and then more information from the SNAP's office, various HUD memos, housing brochures, fact sheets. We have, oh great, that's actually good. Housing brochures and fact sheets, and then we also have some step-by-step packets for advocating for victims who are applying for public and assisted housing using all of these memos. Is also included in the materials. And that we at NIWAP provide technical assistance to walk you through individual cases on regarding access to public and assisted housing and emergency and transitional housing for immigrant survivors of all categories and all types with and all kinds of immigration statuses, who's eligible for what. And Carlo provides, maybe you can tell a little bit, technical assistance on everything related to housing, generally, beyond what we do.
Sure. So NHLP provides technical assistance on issues related to the federal housing program. So we have a grant from the Office on Violence Against Women to provide technical assistance and support on the intersection between VAWA and the federal housing program. But if you have general questions about access to any of the programs that we talked about today, please definitely reach out to us, and we'll do our best to assist you. And just so you know, in the information packet, there's also a Section 214 cheat sheet. Some of you may have seen this in the past, but we went ahead and updated it based on, for example, the inclusion of VAWA Self-Petitioners as being an eligible category of immigrants and some other things. We updated that cheat sheet. That's in your information packet as well. And I think, yes? Leslie,
yeah, Carla, I'm wondering if it makes sense to answer. We have a bit more time to just spend a few minutes answering some of the questions that people were writing in the chat.
Yeah, I was just going to turn to that right now. So we have about 10 minutes left. How would you like to go? Would you like to read off some questions, or I can do that too?
Have some, and then maybe you can grab some that speak to you. Just to make, to clarify a bit more, the first thing I also want to announce, there's also going to be a webinar that we'll send you an announcement to. All of you who have registered will send an announcement for a webinar on Friday that's going to talk about the fact, where VAWA confidentiality is today, VAWA T's and U's are today, and how those programs continue to be viable in today and under current law. And we'll be talking about that in a lot more detail on Friday. And we'll send you the information, everybody the information on that. There's a question about when we talk about VAWA Self-Petitioners, who are we talking? Are we talking about people who've been awarded VAWA Self-Petitioners or people who are applying? And the same question for T's. The answer is in terms of access to public and assisted housing for VAWA self-petitioners, it's from the moment of application through lawful permanent residency, or from the moment of application until, if the case is denied, then they lose access. Maybe we can trade off on questions, Carla.
Okay. There was a question earlier from someone about what if essentially a housing provider was mistakenly enforcing Section 214 on a program that is not 214 restricted. What should they do? I would go ahead and reapply for that program, and if the housing provider is asserting that the applicant does not meet certain immigration requirements, I would ask what specific immigration requirements are there and to actually cite to the authority that they're using. A lot of times folks who operate federal housing programs or they receive federal housing assistance assume that because they're getting federal money, they have to, the folks in their program have to be able to produce a social security number or they have to be a certain immigration status, and that's not true.
And then there's a question about U visas, and somebody asked why U visas don't get housing benefits, and that's because they don't get public housing benefits, and the reason is they're not included, or they're not included in what HUD on the list of programs that are eligible under 214 of the Housing Act. And so that's the distinction, and that's why it's really, as I said earlier, important to screen VAWAs and U's, and where people are eligible for VAWA, they get much more access to public benefits than U visas. So, for example, they also get post-secondary educational grants and loans that U visas don't get. Things like that. And there's, I think, another question that was really good was if somebody's already living in, let's say, and this is a very typical case, you might have a VAWA self-petitioner who's married to a U.S. citizen or a lawful permanent resident, and they're currently living in public housing. When if that victim goes to court and get a protection order, files a VAWA self-petition, and then goes to court and get a protection order to remove the perpetrator, when she removes the perpetrator, or even before she removes the perpetrator, once she's filed the VAWA self-petition, she's eligible to get the housing without proration. She's not excluded from the grant. She gets the full grant just as with the same number of people, like if there were 4 in the family and she hadn't filed a VAWA self-petition and it was the husband and the 2 kids that were getting, the subsidy, when she kicks him out, there'll be still 3 people getting the subsidy.
Mm-hmm.
Leslie,
Yeah, go ahead.
Can I just follow up quickly on Carlos? In the RD program, people who are denied admission to rural rental housing, the Section 515 program, are eligible to use the RD tenant grievance and appeals process. And therefore, if you're denied based upon immigration status and you want to prove otherwise, you should file for an appeal, and the landlord must give you a grievance hearing, which is comparable to the public housing grievance hearing for admissions issues.
So, Carlo, there's a question about, somebody asked whether home and CDBG, if a program is funded under home or CDBG, are they eligible, who's eligible for what?
So
I know you talked about it, but maybe reinforce it.
Right. Home and CDBG are not restricted by Section 214, so they are not subject to the Section 214 immigration requirements. It's possible that there might be a mixed financing situation, but you have to find that out to see if there's a project-based Section 8 involved in there. But generally speaking, there's no Section 214 restriction. There was a question, Leslie, about the joint memo that you talked about regarding programs and services for to protect life and safety. I think because we talked about it in the context of survivors, they wanted clarification that it actually applies beyond situations that apply to survivors.
Say that again. I'm sorry. Somebody handed me a note. Sorry, Carlos. They're handing me a note to not miss TA questions, and I can't do 2 things at once. Go ahead. Sorry.
That's okay. I can also answer you. But the joint memo regarding protection programs and services for protection of life and safety, we discussed it in the context of survivors, but it actually applies to programs and services beyond the survivor situation, right? So emergency shelters generally, safe havens generally, transitional housing where income is not part of the determination of eligibility for everyone, not just in survivor situations.
Right, and it also, so that it's like everyone homeless, and then there's also children that qualify, that have always qualified, abused, run away, and abandoned, correct?
Mm-hmm. Right. Mm-hmm.
So, let me think. Still looking through questions.
Yeah, there are quite a few.
There's a question about when the restrictions apply to the head of household. So let's say you have a U visa case, Carlo, and they have 2 citizen children. Can they get a subsidy for the children?
Yep. Mm-hmm. That was our Jane Smith example. So yeah, they would have to look at the income for the entire household as part of the determination, and then the assistance would be prorated depending on how many of them are ineligible and how many of them are eligible.
Yeah. We have a few more minutes. Carla, do you see other ones? I'm having trouble reading this fast. If those of you who are on the call, if there are particular questions that we haven't addressed that you want to be sure we answer, we still have a few more minutes.
Leslie, this is a good question for you. It's about training and guidance for housing authorities related to the VAWA Self-Petitioner guidance. Do you have any information about that?
We did some outreach to the field, and any of you that know, we have had conversations with HUD career staff on this, and they had asked us to reach out to the field, and if any of you can help us in that effort, that would be useful. They're trying to identify public housing authority staff who have been good in working with victims generally, because I think what they're considering doing is reaching out to some of those so that as the materials and training get developed, they can engage some people in the field. So if any of you have good relationships and have been working with generally on victim issues in a favorable way with your public housing authorities, if you could email info@niwap.org with that information, I'll be forwarding it to HUD staff. But yes, there will be, I know they were talking about developing some training on this. The materials that we've developed and Carlo's developed for this webinar, please share with your public housing authorities. If they have questions or landlords have questions about this, they can call both NIWAP and NHLP. We're happy to help in any way that we can.
Mm-hmm. And just one more, someone's referring to the proration example. So in that example, the head of household was ineligible and the minor children were eligible. The question is, can the signatory of the lease be ineligible for the assistance? And the answer is yes. The lease can be signed by the person who is the head of household, even though the head of household is not eligible for the assistance. There's a slight complication if, based on state and local law, the person who signs the lease must be of a certain immigration status. But if you have a situation where essentially there's a law saying that undocumented folks cannot sign the lease, please contact us and we'll talk about that.
I have one more that I want to answer as we conclude, just to confirm. VAWA self-petitioners don't have to have work authorization to be eligible under Section 214. They just have to have filed the VAWA self-petition, and after they've filed, they are eligible from that time through prima facie, through work authorization, through approval, and through the application for lawful permanent residency, even if she's married to a lawful permanent resident and has a delay in being able to apply for lawful permanent residency. And the last one I wanted to address is that when I talk about VAWA self-petition, it includes VAWA self-petitioners, VAWA Cuban entrants, VAWA Haitians, VAWA Nakara, all the different kinds of VAWA self-petitioners. Defined under the Immigration and Nationality Act.
Mm-hmm. Okay, thanks so much.
We will be distributing. I want to thank you guys all for coming to the webinar and hope that it's provided you answers to information. Carlo, I do believe that the questions and answers in the chat, we could post those as well, or how might we be able to make those? Some people wanted to be sure to have the availability to them after the webinar.
We will figure that out on our end. We did get a number of questions, and for the folks who did not get answers, we will try our best to get back to you and try to respond to those questions. I know a couple of folks had actually LSC-related questions, so we'll forward those to Robin.
Right, and we can send everyone a link to the LSC policies and rules and information, and Robin Murphy from NOADA has been helping us in the chat as well, and she's available for technical assistance on LSC questions, as are we at NIWAP.
Yeah, okay, so all right, so we'll figure out a way to share these questions and responses, definitely to those folks who directly ask us those questions, but we'll figure out how to share them more broadly too.
Thank you for joining us, everyone.
Okay, thank you. Have a great day.